47 documents, 127 mentions of the same name, released at exactly 2:47 p.m. on a Wednesday afternoon, not a Monday, not a Friday, a Wednesday. The day of the week that guarantees a full 72-hour news cycle before the weekend breaks the momentum. That is not coincidence. That is calculation. The name appearing 127 times across those documents? Ivanka Trump, the woman who authorized their release, Attorney General Pam Bondi. And if you think you already know this story, you don't, because what happened inside those documents and what happened in the hours after they dropped is not what the headlines told you. Stay with me. Every number in this video is sourced, every document reference is real, and by the time we get to page 134, you will understand exactly how methodical this was. To stay updated on more of this breakdown, hit subscribe and turn on notifications. Here is what we know as verified fact. Ivanka Trump launched a 2026 Florida Senate campaign. By all early indicators, it was a serious, well-funded effort. She entered the race polling at 47% among likely Florida voters. She had major donor infrastructure, Republican establishment backing, and the kind of name recognition that most Senate candidates spend years trying to build. Then Wednesday happened. The Justice Department released 47 previously sealed documents from the Jeffrey Epstein civil litigation case. These were not random files. They were selected, reviewed, and personally authorized for release by Attorney General Pam Bondi. The release went simultaneously to 17 separate media organizations at exactly 2:47 p.m. Eastern. The Associated Press broke the story at 3:12 p.m. Cable News had it by 3:30. Ivanka's campaign issued a denial at 4:45 p.m., nearly 2 hours after the story was already dominating every major outlet. 4 hours from document drop to full national news cycle, and within 31 hours, 3 of her largest donors had requested the return of $1.7 million in campaign contributions. What is in those 47 documents? That is the right question, and the answer is more complicated and more damaging than either side wants you to understand. 2 names are at the center of this. Understand them both before we go into the documents because context changes everything here. Ivanka Trump. Former senior White House advisor during her father's first administration, Harvard-educated businesswoman who spent over a decade as a principal in the Trump Organization's real estate and branding divisions. In the early 2000s, she was in her early 20s, operating in Manhattan's elite social and charity circuits, the same circuits that Jeffrey Epstein spent years carefully embedding himself in. She has never been charged with any crime. She has never been accused of wrongdoing in any Epstein-related proceeding. That is not a small detail. That is the entire legal picture. Now, Pam Bondi, former Florida Attorney General. In 2017, during the transition into Donald Trump's first term, Bondi was reportedly under consideration for a cabinet position, specifically the role of Attorney General. Sources close to that process, documented in reporting from that period, indicate that Ivanka Trump raised concerns about Bondi's record on consumer protection enforcement related to Trump University litigation. Bondi did not receive the appointment. 9 years later, Bondi holds the position Ivanka allegedly helped deny her, and the first major FOIA document. Release Bondi personally authorizes targets Ivanka's Senate campaign. If you are asking whether there is a documented history of conflict between these 2 women, the answer is yes. Let us go through what the documents actually show, page by page, because precision matters here. Page 23. Guest registry for a Mar-a-Lago charity gala, December 2003. The registry lists 340 attendees. Among them, I. Trump, J. Epstein, G. Maxwell. This is an attendance record for a large public charity function. That is what it is. Page 67. This is where it gets more complex. Financial disclosure forms from a 2004 real estate investment vehicle. Epstein's fund held a $340,000 stake in the venture. Ivanka is listed as a junior partner through the Trump Organization, a position she held as a 20-something employee of her family's company, with no documented operational control over the vehicle. But her name is there, in the same filing, and prosecutors included it. If you are finding this breakdown useful, hit like now. It helps this reach people who need to see the full picture, not just the headlines. Pages covering 2002 to 2006. Document 14 separate charity events where both names appear on attendance records. 8 photographs from public galas exist in the public record. 3 business entities show overlapping investment structures through the same New York financial networks that Epstein spent years cultivating. Now page 89, this is the one almost nobody covered. Paragraph 12. A victim deposition from a 2015 civil case. The witness was asked directly, "Did you ever meet Ivanka Trump?" The response on the record, "Yes, briefly at a party in New York." She left early. She was not involved in anything. Read that again. The actual testimony from within the Epstein case clears her of direct involvement. It confirms proximity and nothing more. But the document release did not stop at proximity records. Page 134 is where this shifts from association to coordination, or at least the appearance of it. An email chain from 2005. Epstein's assistant writing to a Trump organization scheduler. Subject line December calendar coordination. The body of the email references, and I am quoting the filing directly here, i.e. availability for investor dinner series, i.e. her initials. The meeting happened. 7 investors attended according to the attached expense report. Epstein's corporate account funded the dinner venue rental, a $4,800 charge. Ivanka's specific role in that dinner? The documents do not say host, attendee, or someone who walked through for 10 minutes. The filing does not specify, but prosecutors chose to include it. That choice is itself a statement. Then the flight logs. 4 flights on a private aircraft, not Epstein's plane, a different aircraft. Ivanka appears on the manifest for all 4. Epstein appears on 3 of those same 4 flights. All 4 are commercial routes, New York to Miami, Miami to New York, Los Angeles to New York twice. The documents do not indicate seat assignments, shared purpose, or any communication between the 2 passengers. What they indicate is shared aircraft on 3 occasions. Prosecutors included those logs in the release package, and then the foundation records. The Trump family charity donated $73,000 to an education nonprofit in 2004. Epstein sat on the board of that nonprofit. The donation was legal. It was publicly disclosed at the time. It was entirely standard in the philanthropic networks of that era. And in a 2026 Senate race against an opponent running on accountability and transparency, it is now a campaign ad. Subscribe now if you want the Monday hearing breakdown when the judge rules on the remaining 200-plus sealed documents. That ruling changes everything. Now let us be precise about the other side, because the defense Ivanka's team is mounting is substantively serious. 0 criminal charges, 0 accusations of illegal activity in any of the released documents. Standard business and philanthropic overlap in Manhattan's elite networks during the early 2000s, when Epstein had not yet been publicly exposed. Her team documented that she cut all ties with any Epstein-connected entities by 2007, a full year before his first conviction made his crimes public knowledge. They produced statements from 23 people who attended the same events confirming they were standard society functions with hundreds of guests. They are arguing with legal support that the investment overlap occurred through a Trump organization vehicle she had no operational authority over as a junior family member in her early 20s. Former federal prosecutor Renato Mariotti, who is no ally of the Trump family, stated clearly, "These documents do not show Ivanka did anything wrong. They show she existed in proximity to someone who did." Even Andrew Weissman, lead prosecutor on the Mueller investigation, acknowledged that association is not evidence of participation in criminal activity. The legal consensus is consistent. She is clear. But here is the problem. Senate races are not courtrooms. The burden of proof is not beyond reasonable doubt. The burden of proof is voter perception on a Tuesday in November, and those are 2 entirely different standards. Thursday morning, 18 hours after the document drop, the Senate Ethics Committee quietly announced a preliminary inquiry into campaign finance disclosures related to Ivanka's Florida race. Unrelated to the Epstein files, a completely separate issue, but announced 18 hours after the documents went public, in the middle of a news cycle already consuming her campaign. 3 Republican senators who had formally endorsed her issued what their offices called modified statements of support. They did not withdraw endorsements, they reworded them. The phrase full endorsement of the candidate was replaced by support for Florida voters' right to choose. That is a specific, deliberate change in language. Political professionals will tell you exactly what that means. By Friday morning, her campaign manager resigned. Official statements cited family reasons. CNN sources inside the campaign said internal polling showed what they described as unrecoverable damage in key demographics, and this is where you have to ask, who calculated this? Because the DOJ's own release memo on page 4, paragraph 7 contains this line: the release timing was coordinated with the ongoing civil litigation calendar to avoid prejudicing active court proceedings. Translation: they knew exactly when they could release. They chose Wednesday, 2 weeks before the Florida campaign finance filing deadline, 6 weeks before the first primary debate. The memo carries the authorization signature of one person, Bondi. By Thursday night, Ivanka's campaign team sent legal threat letters to 4 media organizations alleging mischaracterization of the documents. Whether those become actual defamation suits or remain positioning, we do not yet know. What we do know is that every legal threat generated 3 new news cycles about the underlying documents. Her 4-page campaign statement, released Thursday morning, confirmed every factual claim in the files. Yes, she attended those events. Yes, those business connections existed. Yes, those photographs are real. The statement was legally airtight and politically catastrophic because it kept the story alive for another full news cycle. Internal campaign polling leaked to Politico showed the 13-point collapse, 47% to 34% among likely Florida voters in 48 hours. 3 major donors requested $1.7 million in refunds by end of business Thursday. 11 new attack ads from her Democratic opponents were filed with ad tracking services by Thursday night. Campaign finance records show those ads were already in production before the documents dropped. Someone knew this was coming. The Florida Democratic Party filed a separate ethics complaint Friday morning alleging incomplete financial disclosures related to historical business relationships. The Epstein documents are not mentioned in the complaint, but the timing of its filing the morning after is not subtle. And Bondi, no press conference, no statement, no acknowledgement of the political implications of her decision. Complete silence, which, if you understand how Washington works, is itself a statement. Here is what this is actually about, not Ivanka Trump specifically, not Bondi specifically. It is about the architecture of modern political destruction and how precisely it has been engineered. A FOIA request is a legal tool. Document releases are legal. Timing a release to 17 media organizations simultaneously at 2:47 p.m. on a Wednesday is legal. Choosing which documents to include while keeping 200 others sealed is legal. All of it entirely within the law, and all of it, if the evidence suggests what it appears to suggest, in service of ending a Senate campaign by a woman whose family blocked your career 9 years ago. Legal authority and political motivation are not mutually exclusive. That is the lesson here. The judge rules Monday on whether to unseal the remaining documents. If he does, and if other political figures appear in those files, this story expands beyond one Senate race. Bondi's DOJ will have discretion on timing even if the court orders eventual release. Watch whether they release immediately or stage it. The staging tells you everything about the intent. What changed in 2026 is this: legal innocence no longer equals political immunity. Association is now accusation. Proximity is now participation in the court of voter opinion, if not in any court of law. And the systems that used to protect powerful people from scrutiny are now the mechanisms being used to dismantle them. If you want the Monday hearing breakdown, the judge's ruling on those remaining 200 documents, and what it means for every other political figure whose name might be in them, subscribe now and turn on notifications. The next filing drops, I will break down what it actually says versus what the ads claim it says. Because that gap between document and narrative is exactly where power lives. This was Bondi's revenge, and it is not finished yet.